We're turning to this man to make heads or tails of the 9-0 Supreme Court ruling dunking atop the NCAA today and what that means for the future of the economic model of the NCAA, which is here's your free education and we'll take everything else, essentially. But I know there's a lot of gray area, which is why we're having the sports professor and the man in charge of the Tulane sports law program, Gabe Feldman, back here on the Rich Eisen Show. How you been, Gabe?
I'm good, Rich. How are you?
You've taken the retirement of Coach K-Well, I assume, correct? You being the Duke.
I'm still in denial. I have a year. He may change his mind.
Okay. So what the heck happened in the Supreme Court today for a 9-0 ruling, Gabe?
It's a remarkable day. There's not much that 9 justices on the Supreme Court can agree on, but one of them is that the NCAA is in violation of antitrust law through its restrictions on college athletes. And the decision itself is actually pretty narrow and pretty modest because it only applies to what are called education-related benefits. So this would be musical equipment or computers or internships and things like that. So it's not going to have a massive short-term impact, but the bigger impact is that the court basically said the argument that the NCAA has been using for decades to justify all of its restrictions on college athletes is no longer valid. So this will certainly open the door to more antitrust litigation that might try to take apart every rule that has been really fundamental or foundational for college sports and may open the door for athletes not only to be paid for their name, image, and likeness, which is the story this month, but also just to be paid to play or to be paid to come to school.
So before we get to the huge potential tidal wave, let's just talk about what we saw today. What will now change in the world of NCAA sports?
What will change as of now is that schools cannot agree to restrict these education-related benefits. So there was a really broad lawsuit and ended up getting narrowed down to these 2 issues. And one of them was what they call in-kind education-related benefits. So there are restrictions on how many computers or musical instruments or pieces of science equipment that athletes were permitted. They're no longer allowed to restrict that. Again, that's not going to be a major change for athletes to get some more musical instrument and science equipment. They're also going to be able to get internships and scholarships post-eligibility, which is not insignificant, but again, not going to suddenly change the model and lead to millions of dollars come in. And they're also going to be allowed now, the schools, to pay up to about $6,000 for academic achievement awards. But they can limit it any higher than $6,000. So that's the immediate impact. Pretty modest. If that were it, I think the NCAA would declare victory and go back to their business as usual. But it's the reason why the court held all that stuff to be illegal that's more important than what they actually held to be illegal.
Gabe Feldman, Director of Sports Law of Tulane Law School, right here on the Rich Eisen Show. And I think let's talk about the what next, because you said that the ruling invites potentially more bites at this apple and for student athletes who want to get paid for their services. And usually, you read an opinion, if I'm not mistaken, because I do have a degree from your esteemed institution of higher learning that you still have yet to sign to make it official, Gabe.
Honorary.
But that's okay. Honorary. My honorary degree. My bad.
Right.
That you then look at some of the concurring opinions, and the Brett Kavanaugh concurring opinion basically says, bring it. Let's go. I'm ready to make this much larger and pay athletes. Am I reading that correctly?
That shows how much your honorary degree has actually paid off. You've read it beautifully. You've explained it beautifully. So there's 2 things. One is the full opinion from the 8 justices that says we're just going to look at the narrow issue, and that narrow issue is those education-related benefits. Those restrictions are illegal. But even in that opinion, they said, look, although we're not addressing pay-for-play or NIL or all that other sort of stuff, the reason for the NCAA's protection under antitrust law that they've gotten for the last 40 years doesn't exist anymore. The world as it was back 35 years ago when the Supreme Court first gave the NCAA its antitrust protection has changed. and they are not entitled to this antitrust protection, but we're only addressing this one little issue. Kavanaugh came in and said, I know we're only addressing this one little issue, but this whole thing stinks. And college athletes are being exploited. These restrictions would be illegal in any other industry. They should be illegal here. This predominantly affects black athletes. And I mean, he dropped the hammer on the NCAA. And it's remarkable because this is a pro-athlete, pro-labor decision. And it came from arguably the most conservative justice on the Supreme Court, or certainly one of them. So if the NCAA gets its most scathing anti-NCAA judicial opinion of all time, and it comes from a conservative Supreme Court justice, that's not good news for the future of the status quo for the NCAA.
Well, how does that happen? Does Kavanaugh, I'm serious, does he walk into Chief Justice John Roberts' office and say, hey, I want to add something? And do they read it first before saying, okay? Like literally, how does something so remarkable in terms of saying, let's keep, congratulations, NCAA. Not only do you lose this 9-0, but, we've just gotten started, essentially. How does that happen?
Yeah, and that's the prerogative of each justice. They can write a concurring opinion. They can write a dissenting opinion. The other justices have a chance to read it and have a chance to join it if they want, so they could essentially co-author it.
Right.
He was alone on this one. So they can't stop him from writing it, but you will notice, or one will notice, that they don't criticize it or try to limit it in their main opinion. So this may have been the other justices saying, feel free to write it. We're not going to join it. We're not going to comment on it. We think it's beyond the scope of what we were asked to do, but it's still pretty telling. Now, obviously, if more justices had signed it, it would have been even more troubling for the NCAA. But this is about as bad as it could have been unless everybody had signed in on Kavanaugh's opinion, and then that had been the actual opinion in this case. And then, so I guess the one piece of solace they can take from this is that it was only Kavanaugh on that opinion.
And then in terms of my reading of things, along with my honorary degree from Tulane Law, from the sports law organization that you had up there, Gabe, my reading correct is that what makes now stop me. People will be saying, this is crazy that the NCAA steps on its own. What? Is it true that the NCAA asked this, put this before the Supreme Court after they got dunked on by lower courts as well? So in other words, this ruling, this 9-0 ruling against them, and then this concurring opinion where Brett Kavanaugh essentially lays out a roadmap for the entire apple cart being turned over, was the NCAA's doing, essentially?
In some ways, yeah. You could, I'll give the football analogy. Although the NCAA lost at the lower courts, it was a pretty small loss. So it was as if they had gotten the field goal and then took the field goal off the board, and then allowed the plaintiffs to come in and score the touchdown. Because what the NCAA, I think I butchered that analogy.
No,
but
I think you nailed it, actually, Gabe.
Yeah, okay.
Right.
All right.
Right.
You said a slam dunk, and I was trying to find a layup analogy.
Oh,
that
good.
didn't really work. But what the NCAA asked the Supreme Court to do, and keep in mind the plaintiffs did not ask the Supreme Court to hear the case. They were going to take their field goal and go to halftime. But the NCAA did appeal because they wanted the shutout. They wanted to end all of these cases. They didn't want the next plaintiffs to be able to say, look what the NCAA is doing now, this is illegal. They wanted the Supreme Court to come in and say, in 1984, in this famous Board of Regents case, you said we can basically do what we want. We want you to reaffirm that now and reaffirm that we are the ones who get to govern college athletics. We get to decide how much college athletes get paid, and we get to create this product. And this product is based on the fact that the athletes are not paid. That's what makes it different from pro sports. They were hoping, with a very conservative court, one of the most conservative courts of all time, that they would have the votes to do it, that they would have enough justices who would say, you're right, NCAA,
Wow.
We are going to give you more protection. Obviously, didn't turn out that way. Right now, they're going to get less protection and maybe even less, again, for the next lawsuit. But what this might lead to in terms of next steps is for the last 6 months, a year, the NCAA has been in Washington, D.C., asking members of Congress to give them an antitrust exemption because they were worried if they didn't get an antitrust exemption, they would keep being sued under antitrust law and eventually lose. And that's where they are now. So the story may not be over yet. It's over in the court until the next lawsuit is brought. But it may be that Congress comes in and says, we don't want college football and college basketball to be destroyed. We're going to come in and give you an exemption.
Or just like it wouldn't actually destroy it. Isn't that what the ruling said here?
Well, right.
Is that's a fallacious argument. That's what the lower court said, too, is that this doesn't destroy it. This is just the way that you're doing it. And as a matter of fact, it's illegal from an antitrust perspective here. And I don't know, I was following a little bit what was going on in the Commerce Committee in the Senate, Gabe, and it doesn't sound like any of those lawmakers are considering giving them an antitrust exemption anytime soon. So what is, I guess, in final, the next step here? Like, does this, because right now, from what you're describing, now some of the student athletes might get more computers and more of that material, and maybe some scratch for an academic scholarship if there's money attached to it. But outside of that, when do you think this might actually change the model of NCAA athletics economically?
Well, so that's the short term just from this decision. But then keep in mind, come July 1, there are at least 6 states that will allow their college athletes to get paid for their name, image, and likeness from third parties. And then we expect more states to follow. So that's going to, again, it's not going to be pay for play, but it is going to be potentially significant amounts of money going to college athletes. The NCAA is fighting that. So they're asking Congress to come in and block those state laws and give them an antitrust exemption. The Republicans in Congress have been more inclined to do both. They have been more inclined both to block the state laws and potentially to give them antitrust protection. But like almost everything else in Congress, there's no agreement, and so there's no law yet. And we don't know how that will end up. So it could be that in 3 weeks, 2 weeks, there's name, image, and likeness payments, and then there's another lawsuit brought that challenges the whole system and says, look what the Supreme Court said, you cannot restrict us from getting compensation at all. The schools can pay us to play, they can pay us to transfer, they can pay us to do whatever they want. And who knows what the next court would say to that, to say, well, wait a minute, that's beyond what the Supreme Court had in mind. But I am confident that there are many plaintiffs' lawyers across the country that are drafting that complaint as we speak.
So it's possible in 2.5 weeks' time that the star quarterback for Florida, University of Florida, who's taken over for Kyle Trask, whose name I don't have at the top of my head, could have a big fat contract for a local car dealership in Gainesville, and nothing can happen. Nothing can be done against that.
I think that's likely, not only possible. I think that deal is probably in the works, and I think there might be some national deals too.
Thanks for the call, Gabe.
Your star college quarterback or point guard or whoever it might be.
Is in a state where this is legal, correct? Right?
Right. And the NCAA is planning to vote this week, maybe early next week, on what to allow the athletes to do in all those other states that don't have laws that go into effect yet. It looks like they're going to allow all college athletes to do it, not just those that are in states that have passed laws. So it is probable that every college athlete will be able to be paid for an endorsement deal, social media appearance, whatever else it might be, come July 1.
Come July 1. That is around the corner. Gabe, thanks for the time. Great to catch up with you, sir.
Great to talk to you, Rich.
You got it. That is Gabe Feldman right here on The Rich Eisen Show. You can follow him on Twitter, as I do, at Sports Law Guy. That's where you can follow him. And he's got a podcast, Between the Lines, where all podcasts are acquired about sports and the law. Hey, you watched all the way to the end. Thanks for that. Watch more right here.